I know that because someone told me, a woman who had driven 40 minutes that morning alone and sat in the back row of my courtroom without saying a word to anyone. She had printed something out and was holding it folded in her hands the whole time the bailiff was reading the docket. She never unfolded it. She never had to. The fact that she was there, holding it, told me something about the man I was about to sentence before I had heard a single word spoken on his behalf. That is the case I want to tell you about. Before I go further, subscribe. The stories I want to tell are not always about the worst of what I have seen. Sometimes, not often, but sometimes, they are about the moments that made me glad I was in that room. Subscribe for those moments. This is one of them. Marcus Ellery was 29 years old when he came into my courtroom on a Thursday morning in early October. He had been working as a tow truck driver for a company out of Shelby County for about 14 months. Before that, he had done warehouse work, some construction, a stretch driving for a private delivery company. He had one prior, a misdemeanor from 6 years earlier, a bad night with some bad decisions, nothing that had followed him into a pattern. When he walked in that morning, he was wearing a gray button-up shirt that looked like it had been ironed carefully and then slept in. He sat down next to his attorney and folded his hands on the table and looked straight ahead. Not at me. Not at the gallery. Straight ahead, at the wall. Like a man who had decided that the most honest thing he could do in that room was to stop moving and let whatever was going to happen happen. I noticed that. I notice when people stop performing. It is rarer than you might think. The woman he had stolen from was named Patricia Okafor. She was 43, a hospital administrator, and she had been on her way to her mother's house on the night of March 14th when a car ran a red light and hit her on the driver's side at the intersection of Lamar and Winchester. She was not seriously injured. Bruised ribs, a cut on her forearm, a concussion that kept her out of work for 11 days. The car was totaled. When the responding officers called a tow, Marcus Ellery was the driver who arrived. While Patricia was sitting in the back of an ambulance 2 blocks away, he went through her car. He took a laptop, a watch that had belonged to her late father, $340 in cash from the glove box, and a small green wallet. He was identified by the dashboard camera on his own truck. His own truck. He did not know the camera was there. Patricia Okafor stood up in that courtroom and read her statement clearly and without theater. She described the watch in 4 sentences. She described what it was when she received it, what its face looked like, and why it had been in the car that night. She said, "I cannot get that back. I know that. What I want is for this to be the last time something like this happens to someone who is already hurt." That was what she said. I have been a judge for 17 years. I have heard victims read statements from that podium that were perfectly reasonable, perfectly understandable, and also about the speaker's anger more than about the harm. Patricia Okafor's statement was about the harm. That is a distinction that matters. It told me something about what she needed from this process, and it was not the maximum. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. I first encountered this case in a file on my desk 2 weeks before trial. The charge was theft of property over $2,500 in value, a Class D felony in Tennessee. The sentencing range on that charge for someone with Marcus Ellery's prior record was 2 to 4 years. The way the file looked on paper, the way the facts were arranged in sequence, the crash victim, the tow truck, the camera, it looked like the kind of case that resolves cleanly in the direction of the top of that range, a person who was already hurt, someone they called for help, the betrayal of a moment of genuine vulnerability. I understood exactly why the prosecution filed where they filed and asked for what they asked for. The logic was sound. But I have a rule I gave myself early in this career and have tried to hold to since. I do not decide a case before the human beings in it have stood in front of me. A file is a summary of facts. It is not a person. It cannot tell me what I need to know to design a sentence that does something more than satisfy the statute. Tennessee law gives a sentencing judge discretion within the range. That discretion is a tool. I take it seriously. Using it well requires something the file cannot provide, which is why I always wait for the room. When Marcus Ellery walked into that room, I watched him the way I watch everyone. He came in behind his attorney, Thomas Briggs, who is a solid public defender I have known for a decade. Marcus sat down and did the thing I described, folded his hands, looked straight ahead. His attorney spoke to him briefly, and he nodded once without turning his head. He was not cold. He was composed. There is a difference. Cold is the absence of something. What I was watching in Marcus Ellery was the presence of someone who had made a decision about how he was going to behave in that room and was holding to it with real effort. Patricia Okafor came in a few minutes later and sat on the other side with the victim's advocate. She put her statement on the table and placed both hands over it, very still. She did not look at Marcus. She looked at the clock on the side wall, the one that is slightly slow and always reads about 4 minutes behind. I have always meant to have it fixed. She looked at it for a long time, the way people look at things they are using to stay calm, and then she looked down at her statement and did not look at it again until she was called. I am still thinking about what this case taught me. Subscribe. Because before this video ends, I'm going to try to say it out loud, and I want you to be here when I do. Subscribe now. The first turn happened on the second day of proceedings during the testimony of Marcus Ellery's supervisor, a man named Gerald Watts who had worked in the tow industry in Memphis for 22 years. Gerald Watts was not a character witness. He had been called to speak to Marcus's employment record and to the company's camera system. He testified about both of those things plainly and without embellishment. And then Thomas Briggs asked him one question that I did not expect the answer to be what it was. He asked Gerald Watts, in 14 months of employment, how many dispatch calls would Mr. Ellery have responded to? Gerald Watts thought about it for a moment. He said, somewhere around 600. And then, without being asked, Gerald Watts said, in that whole time, we never had a single complaint about him. Not one. He said it the way a man says something that surprises even him, not like an advocate, but like someone stating a fact that did not fit the shape of the room. He was not leaning into it. He was just saying it because it was true, and because the question had brought it to the surface. I wrote that down, not because I needed to remember it, because I wanted to. 600 calls, no complaints. And then one call, on one bad night, in a moment that the evidence suggested was impulsive and not planned. That is what the prosecution's own timeline showed. He was on scene for 11 minutes. The theft was not organized. He did not take large items. He did not disable the camera because he did not know it was recording. This was not a predator at work. This was a man who made one very bad decision in 11 minutes after 600 decisions that were fine. That does not excuse the 11 minutes. It does not give Patricia Okafor back her father's watch, but it changed the shape of what I was sentencing. It changed the shape of who was standing in front of me. That was turn one. The case stopped being a file and became a person. Turn two came through a document. Thomas Briggs entered into evidence a letter from the coordinator of a crisis response volunteer program through a church in Whitehaven, not Marcus's church, a church near where his mother lived. Marcus had been volunteering with that program for about 8 months. He drove accident victims to medical appointments when they could not afford transportation. He did it on his days off. He had done it approximately 40 times in 8 months. I read the letter twice. I read it once in the regular way, and once in the way I always read evidence that appears to be doing something, asking myself whether it holds up or whether it has the feel of something assembled for a courtroom rather than something that was already true before anyone was looking. It held up. The coordinator named specific dates. She named specific people Marcus had helped. She described something specific that Marcus had said to her once when she thanked him. I said it is just driving, and he said, no, it is not to the person who needs it. I put the letter down and I looked at Marcus Ellery. He was not watching to see if I was moved. He was looking at the table. His jaw was tight. He knew what that letter said, and he was not using it the way a performer uses a prop. He looked like a man who was ashamed that the good things he had done were being presented alongside the bad thing, because the comparison was uncomfortable for him. That specific discomfort, the discomfort of a person who does not want credit for good behavior after bad behavior, is one of the signs I look for. I cannot explain it fully in legal terms. I can tell you that I have seen enough people perform remorse from that chair to know what it looks like when it is not a performance. This was not a performance. Subscribe. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The defense argument was clear and competent. Thomas Briggs asked for a sentence at the lower end of the range, full restitution, and supervised probation rather than incarceration. He argued that Marcus Ellery had no history of this kind of crime, that the act was impulsive and not predatory, and that incarceration would cost more, in financial terms, in family terms, in community terms, than a structured probationary sentence with strong conditions. He argued it well. He argued it the way a lawyer argues something they actually believe. But the moment that stayed with me was not an argument. Toward the end of his presentation, Thomas Briggs said something that I have almost never heard a defense attorney say from that side of a courtroom. He said, "My client is not here to ask you to forgive what he did. He is here to ask you to design a sentence that gives him the chance to spend the next several years making it mean something other than the worst thing about him. That is all he is asking. That is all I am asking." He did not play it up. He said it and moved on. I think he almost did not say it. It was the kind of thing that arrives at the end of a prepared argument and is more honest than the argument because it was not prepared. Marcus testified briefly. He did not testify at length because Thomas Briggs had rightly judged that the evidence spoke more clearly than a prepared statement would. But he answered 3 questions directly, and I want to give you 2 of them. When the prosecutor asked him whether he had thought about what he was doing when he went through Patricia Okafor's car, he said, "No, that is the honest answer. I did not think. And the not thinking is the thing I am most ashamed of because she was right there, 2 blocks away, and she needed help, and I took from her instead." And later, when Thomas Briggs asked him if he had anything he wanted the court to understand, Marcus Ellery said, "I know that what I did cannot be explained by the fact that I was tired or stressed or going through a hard month. A lot of people are tired and stressed and going through hard months, and they do not do what I did. I am not trying to explain it away. I am trying to understand it myself, and I promise you I am the hardest person in this room on that question." He said that. I wrote it down, not because I needed to remember it, because I wanted to. There is a man I knew when I was young, not well, just neighboring well enough to be aware of his life. He worked for the county road crew for 31 years. He had one very bad year in the middle of those 31, a year with a divorce and a DUI and a stretch of behavior that his children did not speak to him about for a long time afterward. I was in my 20s, and I watched that year happen from enough distance to see the shape of it. What I remember most is what happened after, not as a story with a resolution, but as a fact. He went back to work. He drove the same routes. He did not talk about the bad year. He was not forgiven quickly or easily by everyone, but 31 years is 31 years, and one bad year is one bad year, and eventually the weight of the years settled where it was supposed to settle. I thought about him during Marcus Ellery's sentencing. I had not thought about him in a long time. Subscribe. I have not told you the full sentence yet. I'm about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. The room before sentencing was quiet in a specific way, not the quiet of people holding their breath because they are afraid, the quiet of people holding their breath because they are hoping. I could feel the difference. I have been in rooms where people were waiting for a sentence the way they wait for a collision. Braced, resigned. This room was not that. Patricia Okafor was sitting with her hands folded and her eyes on me. Marcus was sitting with his hands folded and his eyes forward. The woman from the back row, the one who had driven 40 minutes and sat there holding the folded paper, she had moved to the 3rd row by now, and she was watching Marcus with an expression that I can only describe as wanting. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. The prosecutor had asked for 3 years, served at 30%. I sentenced Marcus Ellery as follows. I am ordering you to pay full restitution of $4,720 to Patricia Okafor within 18 months. That number includes the value of the stolen items, the cost of her out-of-pocket medical expenses, and 11 days of lost wages. Patricia Okafor did not ask for the lost wages to be included. I included them because that loss was real and the sentence should account for it fully. I'm also ordering 3 years of supervised probation in place of incarceration. That probation carries specific terms that I want to name plainly. You will maintain documented employment for the duration. You will submit to unannounced check-ins. You will complete 40 hours of community service through a program that directly serves accident victims or emergency response. I named the program specifically, a local organization that coordinates volunteer transportation for trauma patients, the same kind of work Marcus had already been doing on his own. I did that deliberately. I did not want to assign him service that was foreign to who he had already shown he was. I wanted to assign him more of who he already was, under structure, on the record. And there is one more thing. You are prohibited from working in any tow, repossession, or vehicle recovery capacity for the duration of this probation. That condition is not permanent. It is a specific boundary tied to the specific failure, and it will expire when the probation expires. After that, if you choose to return to that work, the law does not stop you. But during this time, that boundary holds. One condition of early completion. If Marcus Ellery completes 200 hours of documented volunteer service, not the 40 required, but 200 total, before the 18-month restitution deadline, I would review his probation conditions for reduction at that point. I did not say to him, I believe in you. I said, here is a door. The door is real. The key is work you already know how to do. Then I spoke to him directly, and I want to say it again now the way I said it then. What you did on the night of March 14th was a real harm to a real person at her most vulnerable moment. You made a choice. And I know you did not experience it as a choice, but it was one, to take from someone who had just lost control of her safety, her car, and her night. You took from her something that cannot be replaced. Patricia Okafor is the one who has to live with that loss. I want you to carry that knowledge clearly for the rest of the time you are in this system and long after it, not as punishment, as a fact about what your actions cost another person. I also want to say something about what I see in you that the charges do not contain. I see a man who has spent 8 months driving strangers to medical appointments on his days off. I see a man who answered 600 calls without a complaint. I see a man who stood in this courtroom and refused to explain himself away when explaining yourself away would have been easier and perhaps more persuasive. That is not a small thing. I am not granting you credit for it in this sentence. The sentence is what the law required me to design. But I want you to know that I saw it. The court saw it. Patricia Okafor, who chose to say what she said from that podium, saw it. Marcus. Do not steal that from yourself again. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. After I finished speaking, I watched the room begin to settle. Patricia Okafor nodded once, not at Marcus, not at me, not at anyone in particular. It was the nod of a person who has said what they needed to say and now intends to leave. She gathered her statement, folded it exactly the way it had been folded, and put it in her bag. The woman from the back row stood up and walked toward Marcus. She did not hug him. She put one hand on his shoulder briefly and then stepped back. Marcus did not turn around. He closed his eyes for 3 seconds. Then he opened them and looked at his attorney. I signed the sentencing order. I capped my pen. I set it down on the desk in a small, ordinary way, and on that particular morning, that small, ordinary thing felt like the period at the end of a sentence that had been a long time getting written. No appeal was filed. I found that out 6 weeks later. I noted it. To me, the absence of an appeal in a case like this one says something specific. It says that the sentence landed close enough to what every party in the room understood to be fair that no one needed to ask another court to reconsider it. That does not mean everyone was satisfied. It means everyone recognized the weight of what had been decided and chose to let it stand. I respect that as an outcome. On February 7th of the following year, I received a note from the coordinator of the volunteer program I had assigned Marcus to. She wrote to tell me that Marcus had completed his required 40 hours in the first 3 months and had continued without stopping. She wrote, "He is the person the other volunteers call when they don't know what to say to someone." I folded that note and put it in my desk. That is the kind of thing that does not end up in a court document. It does not need to. I know it happened. On February 7th, one specific person did one specific thing that they might not have done if that courtroom had made a different choice. That is not a conclusion. That is just a fact, and it is enough. I have come to believe something through cases like this one, not as a philosophy I arrived at in a library, but as a conclusion I arrived at in a courtroom through specific people, specific facts, and specific decisions. The belief is this: precision and compassion are not opposites. The most demanding thing a judge can do is not the harshest sentence. It is the sentence that is designed for the actual person standing in front of you, which requires you to actually see the actual person, which requires time and attention and the willingness to be changed by what you find. That is harder than applying the top of a range. It requires more from the judge. I think it produces more from the person. What this case gave back to me, not as a judge but as a person, is the reminder that it is still possible to be surprised in the right direction. One sentence, then I go back to work. If you have been in Marcus Ellery's position, if you have done something real and caused real harm and have been carrying the question of whether there is a path forward, here is what I look for from the bench. I look for the person who is not trying to minimize what they did. I look for the person who is not performing remorse, but demonstrating it through what they were already doing before they knew the court was watching. I look for the person who is harder on themselves than I would need to be. If that is you, that matters, not as a guarantee, as a real factor in a real decision made by a real person who is trying to get it right. What you do with the information is, keep doing the thing you were already doing. Keep doing it when no one is documenting it, because it shows and it counts, and someone on a bench somewhere will eventually see it. If you have been in Patricia Okafor's position, if you were asked, in the middle of your own loss, to consider something other than the maximum, I want to tell you what I have watched from the bench when people in your position chose that path. I have watched them leave the courtroom walking differently than they arrived. Not lighter exactly, something more accurate than lighter, like they got to say the true thing instead of only the expected thing. I cannot tell you what the right thing to want is. I can only tell you what I have seen happen to people who chose to say what the harm was and then named what they actually needed, which turned out to be something other than maximum consequence. I have watched it seem to help. That is not a prescription. That is a witness account. Subscribe. What I said from that bench was the hardest good thing I had done in a long time. Subscribe and hear it. And if you want to hear the others, there are others. Subscribe and stay. Marcus was working double shifts at a garage in East Memphis. That is where this story began, and it is where it ends. Not with a sentence, not with a ruling, but with a man doing ordinary work on an ordinary day in a life that still belongs to him because a courtroom chose to see all of it and not only the worst 11 minutes of it. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments on these videos are a place for people who understand that justice and the best of what we can be for each other are not different things. Come and be part of that.